that its regulations are conceived in the public interest and not in furtherance of parochial or self-interested concerns of the bar.
Okay, Jeremiah put, if a Michigan prosecutor committed fraud on the court by altering exculpatory evidence in a criminal conduct case, are there statute limitations of filing a complaint on this? What he's talking about is a conspiracy against rights under the color of law. And the statute limitations as are as following. So I figure it'd be easier instead of putting multiple links if I just talk them through this, okay? For criminal charges, conspiracy against rights under the color of law, U.S.C., the federal statute of limitations 5 years from the date of the last overt act committed in furtherance of the conspiracy. So what that means is, every time you file, like I filed with the ARDC, the Judicial Inquiry Board, the appellate court, they didn't want to hear it. Supreme Courts, nobody wanted to hear it. So every time I filed, it was a furtherance, but still they're ignoring it. Okay, so if you're referring to a civil lawsuit for conspiracy or deprivation of rights under the color of law filed under U.S.C., the statute of limitations is not found in federal law. Instead, federal courts apply the personal injury statute of limitations of the state where a violation occurred. In Illinois, for example, the statute of limitations personal injury is 2 years from the date of the injury or deprivation occurred. Okay, so we're going to wind up going back to where he was at. Okay, because knowingly and willingly violating your constitutional rights. Okay, so they're going to go to ignorance of the law. They're going to tell you your ignorance of the law is no excuse. See, and that goes way back. But what about them ignoring the law? Okay. They totally ignored the laws in a court of law, which are the rules of professional conduct. Oh, sorry. See, so we go back to the preamble and the scope. Okay, legal professional relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest, not in furtherance of prerogative or self-interest concerns of the bar. Them placing those statute limitations to sue you is in the interest of the bar to protect them from you. Okay, and once they violate one rule, they violate multiple rules. And I mentioned to them about Rule 3.8. All these are laws required in a court of law for every lawyer and judge, and Rule 3.8 is a special reminder to the prosecutor, okay, to refrain from prosecuting a charge prosecutor knows is not supported by probable cause. Okay, and the Supreme Court said it was their duty is to the defendant and to see that the justice is served, not to prosecute. Okay, then it gets good when you get down here. When a prosecutor knows new credible evidence, material evidence creating a reasonable likelihood the convicted defendant did not commit an offense which the defendant was convicted, the prosecutor shall promptly disclose that evidence, not alter it, destroy it, hide it. Appropriate court or authority, if the conviction was tamed in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes. So if they hit you with the statute of limitations, remind them that that was in violation of the rules of professional conduct in the preamble. They call it a loophole, okay? In line 12, okay, that was in furtherance and self-interest of the bar, okay, not in the public interest. Okay, so that's where you're gonna go, not in the public interest. Oh, wrong. Okay, it's a pretty powerful statement to make. Not in the public interest is a standard legal and regulatory phrase meaning action, disclosure, or policy would harm or fail the benefit of the general community. It is frequently invoked in criminal justice and government information requests to prioritize the common good over personal curiosity. Okay, so you just want a criminal prosecution to determine if pursuing a criminal case, information, FOIA, corporate and public. See, not in the public interest when the potential harms. Okay, so that's a pretty powerful statement to use. Not in the so that statute of limitations when the interest was in the interest of the bar, not in the public interest. It was they wrote it to protect them from you, thus under the color of law. Okay, creating a conspiracy against rights under the color of law. Again, okay, not just a conspiracy against rights under the color of law by depriving your constitutional rights to effective assistance of counsel, you know. So you're going to cite not just the prosecutor for prosecutorial misconduct, but your attorney for ineffective assistance of counsel and the judge for judicial misconduct. And all you need are the rules and the codes. And, when they say, hey, well, there's a statute of limitations, then you're going to say not in the public interest, clearly in furtherance of self-interest of the bar. Okay, so you're going to end up where you started, okay? Okay, Jeremiah, that's your name, right? So you're going to end up where you started, okay? Right back on that line, but you're going to want to read and
The
learn the whole
profession
thing,
has a
okay?
responsibility to assure that its regulations are conceived in the public interest and not in furtherance of parochial or self-interested concerns of the bar.